Hi, I'm Brian Finch, and I'm here with Elin Sigurdson at the Canadian HIV/AIDS Legal Network Symposium here at the Novotel Hotel. And today's big theme has been strategic litigation. And Elin was on the panel this morning speaking about litigation, particularly around the subject of prostitution, sex work, and relating to that. And you're based out in BC. And one of the acronyms of a group you were speaking about, I wanted you to talk about maybe a little bit, is SWAV. Mm-hmm. What is SWAV, and how does it relate to some of the court challenges that are going on today?
Sure. SWAV is actually a short form for Downtown Eastside Sex Workers United Against Violence Society, which is about a bit of a mouthful. And this organization is made up of around 50 sex workers living and working in the downtown east side of Vancouver. They tend to be survival street level sex workers working in very difficult circumstances and living in a very high level of poverty. And they are part of this litigation as one of the plaintiffs. So they are challenging the criminal code provisions, such as the communication law, the body house law, and aspects of the procuring law that affect their ability to practice sex work safely.
So the procuring law, if I can say it correctly, that's the part about the communications?
Well, the procuring law is actually the law that is supposed to stop exploitation in the form of pimping. So procuring, it covers a whole bunch of different activities, including living off the avails of prostitution and among a number of other things. But the way that this plays out with, especially this group of people, is that it restricts their ability to make decisions to do things more safely, like work together, like provide each other with information about safe clients, and things like that. So we're challenging that provision to the extent that it applies to adults and not to traffic people or to people who have been drugged or things like that. So it's about how that works with consensual sex work.
Now today is a day that is a theme around particularly HIV and AIDS. And so I'm just kind of wanting to connect this case to that subject. And how do these two relate?
I think the most specific way that they relate is that sex workers find that the more difficult the circumstances of their work and the more dangerous situations that they're in, the quicker they have to make decisions and the less power that they have in the interaction and in the transaction. So sex workers in one sense are affected by the criminal laws in a way that affects their risk of HIV and other infection, in that where they're disempowered, they have less ability to impose constraints like use of protection, more screening of clients based on their own sense of the person. So they're less able to take safety precautions and put themselves in more difficult and risky situations. So that's one way. Another issue for sex workers is the question of mandatory testing, which isn't a subject of this litigation, but is something that comes up in terms of whether or not sex workers believe that if the law is changed or if it's regulated, they should be required to be engaged in mandatory testing. And that's, I think, highly problematic for a lot of sex workers.
Thank you for taking a few minutes out of your busy schedule today and to explain some of the discussions that were going on earlier today on the panel. And yes, I just thank you.
Thanks. It's been my pleasure.